siblings. And of course, when you said that the Supreme Court, and that is the apex court in India, it has utmost respect in everyone, in every mind here in India also, so is in your country also. So now, and yes, I saw that multiculturalism that you told, and the multicultural countries, exactly. I ditto you for that. Now it makes me to learn that summarily and in broad traits, how similar are the Indian and Canada when it comes to the respective constitutional frameworks, Professor Sébastien?
Well, I just pulled up the second slide. There are principles, there are core principles in India that cannot be amended, but also core principles in Canada that have been provided by a seminal decision of the Supreme Court of Canada in the reference regarding secession of Quebec. Quebec is one of the provinces of Canada, one of the 10 provinces. This is the where French is predominantly spoken rather than English. I come from Quebec. But we do have principles that are identical. Some are similar, but some principles, and we can take these principles for granted. Like the supremacy of the Constitution, which is the rule of law and the reliance on the Constitution in Canada, democratic principles, number 2. But again, let's pause a second about the democratic principles. We take democracy sometimes for granted. As we all know, India is the biggest democracy, and that's very important, in the world. Elections, for example, in Canada take 1 day. In India, it takes several weeks, as you know. Democracy is very important. And because we take it for granted, it is easily taken away if we are not careful. If we don't fight for it, if we don't battle for it, if we don't argue for it, and if we don't support it. But democracy has its flaws, obviously, but it has amazing and beautiful features. So even though we take it for granted, this is a principle that's very important at the core of both our societies. And I refer here to the decision, the famous decision. I probably will not teach anything here, but the decision of the Supreme Court of India in Kesavananda Bharati versus the state of Kerala, which is a famous decision from 1973, a famous decision of the Supreme Court of India. But here, for example, just to go back briefly to the first point I was making about the lack of knowledge, ask any student of constitutional law of Canada if he can mention just one decision of the Supreme Court of Canada regarding the Constitution. Nobody will know about the decision in Kesavananda Bharati versus the state of Kerala. Nobody, except Indians, perhaps, but there's a gap that needs to be filled. Another point that we didn't discuss, we touched upon it very briefly, that's number 5, because I'm talking about things that are identical between our two countries. So number 5 is the federal character of the Constitution as per the decision of the Supreme Court of India. And the exact same principle is provided as a core principle, a basic fundamental principle by the Supreme Court of Canada in reference regarding the secession of Quebec. That's the principle of federalism. Why is it so important? Why should we care? Well, both, like I said earlier, both our countries are multicultural countries, but also geographically speaking, both our countries are vast, geographically vast. So also there's regional differences beyond multiculturalism. So provinces or the subdivisions in Canada, there's the entire issue. We're not going to delve into details about this, but there's the issue of the division of powers. And the Constitution of India also directly speaks to it, gives some specific powers or attribution of some jurisdiction to subdivisions in India. Some prerogatives, should we say. So to move on to the differences, but I'm not very keen to say these are differences. These are more distinctions. So regarding, for example, the secular character of the Constitution in India, as opposed to in Canada, the fact that Canada does not and should not, according to the current state of the law in Canada, and I cite here a really quick excerpt of the decision in Northcrest versus Anselm, the decision, fundamental decision of the Supreme Court of Canada in 2004. So the state is not in position to be the arbiter of religious dogma. So basically, in Canada, the state takes no position. It's a little bit different than in India, whereas in the Constitution, the secular character of the Constitution, this is a fundamental value, but still in Canada, Section 15 that we mentioned earlier quickly, which protects the equality rights, that also includes no discrimination for religion. Section 2A of the Canadian Charter of Rights and Freedom also protects the freedom of belief, which is said in plain English, the freedom of religion. So that's something we still have similar rights that are protected. It's just the way they are approached or the way they are implemented varies somehow. Also, the last one is I touched upon it when I mentioned the federalism feature of both as fundamental distinctive characteristics of both our countries. But number 4, the last one is the separation of powers, the division of powers. Actually, it's not separation, it's division of powers, and the way it's called in Canada usually, but separation of powers as per the decision of the Supreme Court in the reference regarding secession of Quebec. But so in Canada, and I will not hear for the purpose of this interview, but Canada does not insist, and that's what the Supreme Court said in the decision I mentioned earlier at paragraph 15, Canada does not insist on a strict separation of powers. Not saying India does necessarily, but this is approached differently. So the separation of powers between the Montesquieu principles, basically to go back to France some centuries ago. So the separation between the legislative, the executive, and the judges, the judiciary is not, it's more, it's strange to say, but it's more fluid in Canada. It doesn't mean that there's no separation of powers, but it works differently. So that would be probably the main distinction. So that's a roadmap of, but briefly, if I may mention as an aside, but very quickly, the way the Constitution is amended works differently. It is not easy at all to amend the Constitution, to change the Constitution in both countries. But as the decision Kesavananda Bharati of the Supreme Court of India stated, the basic structure doctrine does not exist in Canada. It's not something Canada relies on. So that's a major difference. It doesn't mean that Canada's constitution can be amended or changed easily just by the will of the parliament or the legislation. I refer to paragraph 43 and 41 and 44 of the Charter of Rights. It's very complicated, but it's still done in the different fashion. So that would be a difference. But again, differences. So we've seen some things that are identical, some things that we may say, yeah, of course, democracy. Almost all countries in the world are democratic to nowadays. So what's the big deal? First of all, it's not true. There are many countries that do not recognize as a core fundamental principle democracy. Also India, I don't want to flatter Indians, but India must be and remain a role model when it comes to democracy. And I don't want to mention any other countries in the world, but India plays a very prominent role as a supporter. And I'm not only speaking in Asia, but also in the world, because it's the largest democracy. So just to go back to the differences between our countries, again, differences should not make a student or an academic conclude, well, yeah, Seb, you're right, but the things that are identical, it's fine, who cares? No, we care. And the differences, as I said, enrich the debate and makes the discussion between our two countries more interesting. Not necessarily to change the Indian Constitution or to change the Canadian Charter of Rights and Freedoms. Not the purpose, but at least the understanding of the mindset, the rationale behind adopting these principles based as an underlying statement here, based on the fact that both our countries are so similar with respect to major items like multiculturalism and democracy and all those things. So these are pillars of our countries. So then it is very important to keep the debate and the discussion ongoing between our two countries. And the differences here should not, like I said, discourage any researcher, student, or academic to say, well, who cares? Who cares about Canada? It's different. I care about India. No. Use it. Learn it. And maybe you'll argue it in court. Who knows? Just as a reminder, not a lot, but both the Supreme Court of India and the Supreme Court of Canada, not enough, to my opinion, not necessarily to rely on those decisions, but each court cited the other court a few times. So it happens. It wouldn't be totally strange in a constitutional law case that to have an Indian case to be argued in Canada. That would be unique. It would be a fresh start, obviously, because it doesn't happen often. But it is conceivable. And the same thing, vice versa, a Canadian case in Canada from the Supreme Court of Canada that would be cited in India in a constitutional case, maybe it would make some judges frown or some judges be doubtful, but it is up to the person who argued the case, say, hey, let's look at what Canada has to say. Or in Canada, hey, let's look at what India has to say about this in that context.
Very, very interesting, Seb. That was really very interesting. So yes, I can see that you based it on the 5 basic pillars of the Constitution of your country as well as India. So yes, the supremacy, secular character, whether it is separation of powers, and starting right from Keshwananda Bharti case, that is the bedrock here of the Indian Constitution also. Yes, it's very, very interesting. And the time which you are showing to us, it is really very interesting to see that, yes, when both the countries and the laws and the courts are in total consonance with each other, and can you be these latest judgments or these landmark things can be used in the courts, it will be very, very interesting. Yes. Indeed. Moving ahead, now I would like to just take you to the criminal side also, because we are basically keeping today's talk on 2 basic aspects, that is the Constitution and the criminal.